with his friend. Grant Neal says he and his girlfriend were, or this woman that he knew, were having unprotected sex, but she stopped him and asked him to wear protection, which he did immediately. The next day, his girlfriend told her friend about the incident, and that friend thought that this was a rape, even though neither one of the participants thought it was a rape. And so the friend reported it to university authorities. And even though the girlfriend testified to college administrators, she was not raped. They did not care. Listen to the part of our interview with Grant and his attorney. Andrew, we have been covering this repeatedly, and what has happened in these cases from college campus to college campus is the administration has set up young college men to have the book thrown at them and basically to be convicted without a lawyer and under a standard that no court would accept. Isn't that true, Andrew?
That's absolutely true. And in fact, what is unfortunately happening is the Obama administration has laid a very heavy hand on the disciplinary process in colleges such that it's virtually assured that an allegation will turn into a finding of responsibility and expulsion.
I've been having to deal with this for so long, and it's just really a really hard thing to do when all the rights that you're given as a natural-born citizen of the United States and as constitutional due process, I didn't even have that. So that was extremely difficult to handle.
What are your odds of reversing this policy or getting the Department of Education to listen?
I think it takes a situation as dramatic as Grant's to have the people of this country and the Department of Education sit up and say, yes, we want to be proactive about sexual assault, but we can't do it at the cost of due process.
Joining me now, Arthur Aidala, who's a New York trial attorney and Fox News legal analyst, and Mark Eiglarz, who's a criminal defense attorney, former prosecutor. Great to see you both. It doesn't sound ridiculous. It is ridiculous. It's ridiculous. Well, neither party thinks that there was a rape.
Of course it's ridiculous. Megan, I looked up in the dictionary under miscarriage of justice, and you know what I found? Not that, because they list words individually. But if they clump them together, they would have miscarriage of justice and this case, because it's fundamentally unfair. No due process, and now he's labeled a sexual offender and can't get into any college.
Listen, Megan, God bless you for talking about this now. I've been handling cases like this for a decade. That's just the environment that it is in education.
No, that's not true. The Obama administration changed the standard to just preponderance of the evidence to basically get yourself booted off campus. You just have to prove by 51% that you were raped, or in this case, that somebody you know on campus was raped. And the accused has very few rights. He's not allowed to confront his accuser. He can't have a lawyer in a lot of these proceedings,
correct.
Arthur.
You're right. But that's what's been going on in educational facilities for quite some time now. This is not a brand new thing. I've represented people. You're right. I'm not allowed to be there. I'm allowed to write a letter, but I'm not allowed to be there with my client. As a criminal defense attorney, that makes your skin
So you can
crawl.
get a guy labeled a sexual offender and take away his college career. He wants to be a doctor, 3.67 GPA, promising athlete, done. You're done. And good luck getting into another college when you have that on your record. I got to move on because we have two other cases to get to. We're going to continue to follow this case. Mark,